Now we'll come to the IP enforcement strategies. Again here, see, there are so many ways of learning, but you all know that when we are very young, we learn so much. The reason being our learning capability is more because that is the age when we question everything. So when you start asking questions, then the answers which you receive will get into your memory. That is how the learning becomes etched in your memory. So when they said like this is the topic, then without even, first I framed the questions, then I will go to the answers. So first I framed why, what, where, how, when and whether to go for these enforcement strategies. Now I'll try to answer one by one. Why? Why do you need enforcement strategies? Reason is that most important reason why do you go and file a case for an IP infringement is that, yes, you have to stop the infringement. That is the most plausible reason that you have to stop the infringement. But in practicality, we also see so many other reasons which come into picture. That is, sometimes the mark has to be well known, visibility is needed. So the visibility will come only if you are keeping quiet in the crowd, nobody will notice you. You make a lot of nuisance and noise. People know, who is this person who is keeping on making noise, lot of sound he is making. That is done by making lot of litigation. Of course, that is also part that you should also have a case to file it, but definitely if you want to make yourself presence felt, then you have to make your presence felt means you have to make a lot of litigation in the court. So that is another reason. Then also it can create a barrier entry to your competitor, especially in patent litigation. That can be used as that you know that another person is coming in the same technology, right? How do you stop your competitor? Legally, I am saying. Legally, what you can do is that you go and file all his patent oppositions, everything, whatever is legally possible. You consult with your patent attorney and the patent agent, then wherever it is possible, go. That will create some barriers for the competitor to enter. So that is also another reason why you should file. Then the last, which we also see in so many cases, that emotions, ego and anger of the person. To his personal ego and personal anger also we have filed so many cases. But most important, please disclose everything to your doctor and lawyer, right? So accordingly we will craft the document. Because we know that in anger and ego you may speak, but we should know whether you are speaking in your anger or ego. So accordingly our draft will also go that, so that it can protect you in the final decision. What type of remedies available? Again here we know all that basically there are three types of remedies available for the IP related issues. One is a civil remedy, which is most sought after. Then comes also, there are criminal remedies also available. The Trademark Act gives you criminal remedies also, and the Copyright Act also gives you criminal remedies. Again, it depends on the case-to-case basis, like on whom you are going to approach, why you are going to approach. So that depends on your decision to go for the criminal remedy or a civil remedy. But as I said, most popular remedy is the civil remedy, because in the criminal remedies there is an intention part which you have to prove. And most important, you have to get an registrar's prior approval. So keeping confidentiality with the registrar, getting approval, time process, and also that you have to go behind the police people. So it all depends on who is your infringer. If your infringer is in large number with low value, large products, then it is better you go for a criminal prosecution. Otherwise, it is advisable if you are targeting a single person with a good background, industry standing, it is always we advise them to go for a civil remedy. Then the administrative remedy, what we here mean by is that we have this customs department. So anything, any infringed products which are entering the shores, we can also give in writing to the customs. That particular note will be valid for 1 year. So 1 year, any particular infringing products which are coming inside, they will notify to you. They will also send a notice to the other person. This is very effective in the case if you are going for an FMCG goods. Especially we know now that from China it is coming. A lot of FMCG goods are coming inside in counterfeit products, as Preeti said. So for these type of remedies, these administrative remedies are suggested. Now then again, where to file? This is again one strategy which we used to give. You all know that now 90% of the companies have their registered office in Delhi, the preferred destination. Because there, as I said already, they have started the IP division and they are more sensitive to the IP litigation. So most of the companies are, in order to take the domicile advantage, they go for the preferred place is Delhi. But however, even in Chennai, what we say is that if you are within the Chennai jurisdiction, you have the advantage of moving into the original site. Suppose if you are in Bangalore, you have to go to the city civil court. Unlike in Chennai, where you can use the expertise of the high court. So these all strategies which we can work it out and give. And where is your IP registered and what is the damages it has cost you, damage it has cost you. All this will be considered, and then at the end of it, it will help you to maximize your success. Then how to prove? In the case of copyrights, you have to see that it is copied or it is substantially copied. These are two things. But suppose we are appearing for the other side, normally we see that also as a defense, we anticipate that. Normally they say I am an innocent infringer. So the moment you put them on notice, then this defense goes away. The second thing is that they can say independent generation. Then that also for that, for example, in software copyrights, we say them to put a dummy code in the original source code. So that if they say that no, it is an independent generation or black box technology, we can always prove in the evidence that it is not so. The source code has something dummy which we have inserted, which they also have copied. And always comes the classic doctrine of fair use, that again case to case basis we advise them. But most important is that when we file the plaint itself, you should ask the person what all the possible defenses the other side will take. So you should disclose everything to your lawyer. That is most important. Then similarly in the case of trademarks, the most important thing is the likelihood of confusion. Here I would like to say that she told that even the trademarks you need not get registered. You get a passing of action also. But there are 2-3 specific advantages over the unregistered trademark. One is with respect to the jurisdiction. If you are registered trademark, he will come to your place. You can always be a dada in your place. You can fight well rather than you go to his place and fight. So that advantage is there. Also that you can have the damages. See, like in the case of infringement, you need not show that there is actual damage has happened because he has infringed. He has infringed your legal right. So it is whatever is his profit is supposed to be your profit. But in the case of passing off, you have to show that whatever he has taken out from me is because it would have come to me that he has taken because he has used my mark or he has passed off his goods as that of mine. So the level of convincing the court will be more and more, the damages which you may receive will also be lesser. So always it is advisable to go for a registered trademark. And what are the other possible remedies which you can get? You can get most important remedies are the preliminary injunction. Even before the Commercial Court Act came into picture, we know that we are a country run by billions of people, but not adequately that much judicial infrastructure is there. When you compare the workload of the Supreme Court of US and Supreme Court of India, it is 1:400. That is, there are only 10 judges there who decide 2 cases, 3 cases in a day. But here, every 2 judges decide 200 cases a day. Or they take into their board 200 cases. See the workload. That much high. So earlier, the remedies which for the IP remedies which we get is only interim remedies. The moment we get the interim remedies, we will forget it. There are some popular IPR reliefs. They are popular because though they can be called by a simple name, the doctors and lawyers prefer always to play with the words. Some things which can be directly say, which we will use some technical terms. For example, they call arrhythmia. Nothing, your palpitation goes up and down. The heart functions this way, that way. But they say it is myocardia arrhythmia, like that they say. That then, oh, doctor is saying something. Same way, use these terms, ant and pillar order. Some of my clients are sitting. I know that we have got a lot of orders for them, but they do not know that is called ant and pillar orders. But the moment we'll say, yes sir, the moment you file an IP suit, we can get ant and pillar order, we can get John Doe orders, we can get Norwich Pharmacal orders, and we can get Mareva injunction. These are nothing but we can get some injunctions, we can get stay orders in simple languages. But there are some flexibility or changes have been made, especially for the sensitive nature of the IP, because it can exist in so many places at the same time. The physical property, if I own a car or I own a house, it is in Madipakam means it will remain in Madipakam only. Somebody is going and making a misappropriation, then I can go to that court alone because it only exists there. But in the case of intellectual property, it exists in multiple jurisdictions, multiple places at the same time. And it can be infringed by that person, and it can happen on a continuous nature also. So taking into account all these things, the courts themselves have molded so many, what is that called, reliefs. So some of them are these, and the recent one is the dynamic injunctions. Like you know that in this case, UTV versus 1337. What happens is that by changing one letter or two letter, the website name can be altered, but they may be infringing some of the rights. So it may be, let us say, xyz.com. They may put xyz1.com, xyz2.com. So every time you can't go to the court and get an injunction. So they give a blanket injunction, what we call a dynamic injunction. The Delhi High Court has given in that, where they said that he is allowed to go to the joint registrar, no need to approach the court. The moment you see a new website coming with the same person or a different person, then you can just file a memo and it will be added and the injunction automatically applies to them.